Good morning, good afternoon, good evening. It's Patriot Smoothie here to summarize day 30 of the trial of Tamara, Lich, and Chris Barber, and you're going to want to watch this one all the way through because believe me when I tell you, today was a very interesting day. We had Miss Magus, counsel for Chris Barber, finishing up her submissions on why the Carter application should be dismissed. A reminder that the Carter application is an application from the Crown to have words and actions by one party apply to the other party, the co-accused in this case, who is Tamara Lich, represented by Mr. Granger, Mr. Greenspun, and others. So this is a phenomenal example today of a culmination of everything we've heard in the trial. Diane Magus laid it all out for us to see. It's all there. Again, let me know down in the comments what you're thinking about all this. And guys, it's a tremendous amount of information today, so I'm going to have to rely on the notes. Again, I'm not in court right now, so I'm going to have to, I did my best to research multiple sources from inside the courtroom to get the fullest picture of what happened there, to summarize. And I've, as someone who's followed this trial from the very beginning, who's been physically present and reporting for the vast majority of the trial, I can tell you that I have a lot of opinions. And believe me when I tell you that I've been very conservative in sharing them with you. I think that I have given this whole proceeding an undue, not an undue, but a lot of respect, both to all parties. I think I've been very respectful, very conservative in my opinions, especially on some of the things that I feel very strongly about. And I've just done that because I think it's the right thing to do. But as this goes on, I think I'm going to be sharing more and more of that with you. So as we go through all the bits of information today, I'm going to delve into a bit of what I think it means, just a little bit. And again, I'm a nobody. I'm Patriot Smoothie. I'm not a lawyer. I'm not a paralegal. I'm not a legally trained person. I'm just a citizen who participated in the Freedom Convoy, who has a voice, a platform, thanks to all of you. And let's go through all this without any further ado. So the first thing that happened was Miss Magus was talking about a text exchange between Officer Bach and and Mr. Barber, where Officer Bach supported Mr. Barber's idea of a slow roll through Parliament. And Miss Magus said that this was an example of Barber's intent to participate in lawful protest, where he's doing things, running it by his primary police contact, who is Officer Botch, as we all know by now. This just goes on. Miss Magus spent a lot of her time today demonstrating how Chris Barber worked with police every step of the way on everything that was going on. And clearly someone who was engaged in a inherently illegal action with a common unlawful purpose would not be doing these things of trying to maintain good faith with the police, of cooperating with police. So there's a lot of things that have to be considered here when the Crown's trying to prove that these two co-accused are engaged in this common unlawful design, this inherently illegal thing where they agreed very specifically to do it together and to further it. And at the same time, you have Chris Barber constantly working for police, not for police, constantly working with police, constantly telling people to be respectful of police and telling them to shake their hands. We've been over this. So again, another TikTok video brought up where Mr. Barber noticed a case of rocks in the street where he told people to protect them and not allow anyone to throw them, which is not something that someone who's engaged in unlawful, tumultuous, violent, whatever you want to call it, protest or unlawful assembly would do. If they were there to cause mayhem, they would be throwing rocks, they would be causing destruction, they would be looting stores. None of that happened during the Freedom Convoy. So very and again, the February 7th honking injunction brought up, very important, the Justice McLean decision, which was several different people brought that forward, so-called residents of Ottawa who did not like the honking, and the only term of the injunction again was to stop honking, whereas Justice McLean indicated that protesters were at liberty to continue their peaceful protest. They're at liberty to engage in a peaceful, lawful protest. And again, it doesn't say remove the trucks. It didn't say anything else. It just said please stop honking, and by and large that was followed. Again, as I always say, a major source of contradiction in a lot of the testimony we've heard, because a lot of the 16 Crown witnesses said that the honking was never ending, never stopped, continuous, but then they later on in their cross-examinations with the defense in this trial have said that no, it actually got more sporadic after the 7th, which is a major contradiction. And once you contradict yourself as a witness, as I understand, your credibility is out the window, and everything you said is up for question and carries very little weight afterwards. I guess it's all situation to situation, but that's certainly one interpretation and something to keep in mind. And Again, another video, Barber saying, stay peaceful, no matter what happens, comply with police. Not the actions of someone who's engaged in a common unlawful purpose, a common unlawful design, an inherently illegal action to, no matter what happens, comply with police. Come on. Again, another video where Barber is saying to be respectful, to protest peacefully, and then it's interesting because apparently at this point, Justice Perkins McVeigh noted that it seems that Barber's statements in this video, I assume, are consistent with Inspector Lucas, and again, that was a long time ago. My memory is not the best. I don't have a photographic memory. I can't remember exactly what Inspector Lucas said, but I assume this means in regards to how Inspector Lucas was testifying that there was Mr. Barber was constantly saying, be peaceful, comply with police, so on and so forth. Next, there was another TikTok video that Miss Magus mentioned where Barber says again, no matter what happens, remain peaceful, comply with police. So this is just the theme of him saying it over and over and over again. Not someone who appears to be engaged in a tumultuous event where people could reasonably fear for their safety when the so-called king of the convoy, as you will, Mr. Chris Barber, is constantly telling people with whatever voice and power he has to be peaceful and comply with police. I don't know. How do you take that and then say that the person's engaged in inherently illegal action? You don't. It requires so much speculation. The inference is made with what the evidence presented says that Mr. Barber is constantly telling people to be peaceful and respectful of police. That's the evidence. There's nothing else. There's no video of him. There's one video, I think, where he's on a corner somewhere joking about an intersection. And as the so-called king of the convoy, to my knowledge, there was never any evidence presented that people actually took that video seriously, I think it was beside the National Art Gallery where he joked, that looks a little lonely. And there was never any evidence presented by the Crown or anybody else that anyone actually listened to that joke in that TikTok video from the so-called king of the convoy, the primary organizer here, and rushed to fill in and block that intersection. It didn't happen. So the command and control element that needs to be demonstrated of Mr. Barber has not been done. The evidence is not there. This Carter application and the trial, it's not there. Another video, the agreement of February 12th between the convoy protesters and the city of Ottawa is referenced now. Like, why would somebody engaged in an inherently illegal, tumultuous event, an unlawful assembly, attempt to have a agreement with the mayor's office? Does that, as Miss Mega says, does that make the mayor's office a party to this common unlawful design, to this conspiracy? Are they now a party to it because they've engaged in this agreement and created an agreement with Chris Barber and others? Like, it doesn't make any sense. Just doesn't. And so back again, another TikTok video from February 14th demonstrating again lawful intentions where Chris Barber is introducing lawyer Eva Chipiak, where he says, this is my lawyer, keeps me out of trouble, keeps me out of jail. Why would somebody engage in inherently unlawful, tumultuous activity involve lawyers? Doesn't make any sense. Doesn't make any sense. I'm going to keep reiterating that because it's a point that needs to be driven home. Again, another TikTok video where Brian Peckford, the last living signatory of the charter, and again, thank you to the Democracy Fund, Aidan Helmer and others for all this wonderful, fantastic reporting you're doing and keeping everyone and keeping the lights on this thing so we can have transparency and actually the intentions of the open court principle are being affected and carried on through your work. So thank you very much for that. We need transparency. So in the video, Brian Peckford says, hold the line. And Miss Mega says that this shows that there were multiple people using that expression. Again, we've talked about how so much of the case seems to hinge on that expression. And she adds that Mr. Peckford, as the last living signatory of the Charter of Rights, may know a thing or two about charter rights. That's very true. And then the Declaration of the Emergencies Act is brought up. And Magus points out that lawful protests are carved out as an exception to the Emergencies Act and would therefore have still been permitted despite the Act. It's true. The Act makes very clear. A lot of the Act was not met. The threshold of the Act was not met. It's very clear on what the Emergency Act spells in very clear language, what is required to invoke it, and they were certainly not met during the protest of January and February 2022. Again, the Ambassador Bridge was settled by that point. Coots was settled by that point. Emerson was settled by that point. The only thing going on was Ottawa. There was emergency lanes maintained. There was no justification for the Emergencies Act. Even CSIS testified at the POEC that their threshold wasn't met, and the language in the CSIS Act for their threshold of engagement is the same as the language in the Emergencies Act. I might be misrepresenting something there just very slightly, but the idea of what I'm saying is correct. I might be misquoting the actual act there, but the language in one and the other are the same. And also the Emergencies Act stipulates that no other law of Canada can deal with the so-called emergency as a necessity to invoking the act. And that's really bad because Brenda Lucki attended a cabinet meeting, former commissioner of the RCMP in Canada, where she said that she believed there were still lots of tools left in the toolbox, including the criminal code, which on its surface disqualifies the use of the Emergencies Act when the chief police officer in the country believes that there's other tools for dealing with it. And the public order plan was created before the invocation of the Emergencies Act. In addition to that, Ontario's version of the Emergencies Act was in effect. So, and as Commissioner Rollo famously said, a reasonable person could come to a very different conclusion than I have, and many reasonable people have come to very different conclusions. Anyways, we continue. The injunction of February 16th, now 10 days after the original February 7th injunction, where Justice McLean again held that peaceful protests would still be permitted as a protected right. At that time, with the Emergencies Act in force, a justice of the peace or a judge in Ontario, Justice McLean, saying, keeping the terms of the injunction, the Horn injunction, the exact same. No order to remove trucks, etc. et al. Where does that leave us? And again, limited interactions. Officer Sear had limited interactions with Mr. Barber, but said that he was amenable to police, working with them, always respectful. This is the same theme that we've heard from Officer Batch and Officer Blondie. It just goes on and on. So the Crown now gets their chance to respond, and this is the part we really need to pay attention to. And sorry if this runs a little bit longer than you're used to. Stick around. It's important. We're going through the important pieces here. So the Crown states that based on some of the comments made by Magus yesterday afternoon, this morning, they will be amending their response outline again, which is the basis of their Carter application, because basically they said that some of Miss Magus's statements were convincing. In other words, I think they recognize that a lot of the points being made by defense counsel is landing with the justice, and that they need to adjust their plan of action because it's not going to work as they have it. So that's more or less what they said. Now, so sorry, that wasn't the Crown's beginning. They stood to say that. So Magus comes back to the legal arguments and said that the court needs to consider the totality of everything. And when you look at everything, the court could not, without speculation, find that there was an agreement to commit any of the conspiracies alleged by the Crown. Very true. I tend to agree, wouldn't you? Look at the evidence that's been presented. It's very weak, and there requires a lot of speculation for the Crown's points to land, which is not how it works. That's not the standard of justice in our country and in any democracy, where the standard of justice is, proof beyond a reasonable doubt, not proof that you need speculation to even begin to quantify, to achieve. It's not how it works. So Ms. Magus says that there's no messages between Lich and Barber between February 17th and 16th, quite a gap, and that the court must consider the lack of evidence in that case in making the determination again that there's a solid agreement between the two of them, that they're in constant communication in furtherance of the common unlawful design, the conspiracy, the inherently illegal intentions of protesting, apparently. So now the Crown begins. The Crown says if there was no evidence of criminality, a directed verdict would be the motion instead, but that's not what's before the course. But that's not what is before the court at that time, and that this is instead a defense application to dismiss the Carter. So that's really interesting. The Crown is saying that this is not an application for a directed verdict to just throw everything out. Instead, this is just a motion to dismiss the Carter application, so therefore you shouldn't dismiss the Carter application. Solid logic there. And we don't know what's coming next. There are other defense motions and applications that are coming. As you may recall, the Crown wanted to know what they were, and the Justice Perkins McVeigh said that, no, actually, I'm not going to order the defense to tell you what their strategy is. So we don't know what the next application is. Who knows what it is? And then the Crown says that when the defense is unable to raise serious concerns, the Carter test should be applied at the end of the trial. Well, I think the defense is raising very serious concerns wherein there's no evidence to support the Carter application, and all three rungs of the test fail on the face of itself. So, I mean, come on. It's a little bit comedic. I'm sorry. I mean, it's 30 days of this, and there was plenty of opportunity to present solid evidence, and there is none. The Crown states that the defense argument is premature because Perkins McVeigh has not ruled on the lawfulness of the protest. So, them saying that they're not engaged in inherently unlawful activity by coming to protests in Ottawa is not inherently a good argument because the justice hasn't yet ruled if the protest itself was illegal or not. Nonsense. The Crown says that whether or not the protest was protected, it's not before the court whether that's protected or not. There's no constitutional question, so there's no constitutional question with respect to the criminal offenses and what we're dealing with. Weak sauce. The Crown goes on to say that there has been a common theme that the protests were peaceful, and that they added that the Crown has never alleged that the protests were violent. Well, of course there isn't. There was no allegations of that because there's hundreds, if not thousands, of evidence of live streams just showing a jubilant atmosphere where people are finally being able to intermingle, to socialize, and to feel like people again. There was certainly no atmosphere of violence there. And then the Crown goes on to say that nonviolent protests are not necessarily peaceful. Wrap your mind around that, I guess. Then the Crown goes on to say that the disruptions were significant and although nonviolent should not be characterized as peaceful, they resulted in criminal charges. So the accused were charged. So therefore, the protests are not peaceful because they were charged. Very circular logic there, I think. That's how I perceive that. And then the Crown says the Carter test itself, that regarding the first element of furtherance, what was done, whatever that is, which was very little. I mean, over many days of not talking between the two accused, no specific date or even nature of the agreement between them for this common unlawful design that the Crown has presented. None of that, but nonetheless, whatever was done can help establish the conspiracy itself. Okay. We go on. Again, sorry about the length of this, guys. There's a lot of stuff to cover here that we need to get over. And then the Crown goes on to say there must be a prevailing, continuing, dominant plan. Individual acts can change. And then Justice Perkins McVeigh says, for a common unlawful purpose. So just because you have a plan to come do something doesn't mean it's a common unlawful design. It has to be a common unlawful purpose. You have to be inherently illegal in what you're doing. You can't just come together and do it and then, get charged and have Carter apply because two people were doing something. It doesn't work like that. And then so the Crown then attacked the definition of a unlawful assembly, and specifically the word tumultuous, which is the definition of a riot, I guess, in our law, and of an unlawful assembly as well, and says that the Crown continues that tumultuous behavior does not have to include actions, but only requires a reasonable person to fear tumultuous behavior erupting. Nonetheless, disregard the hundreds and thousands of hours of live streams that shows a peaceful, cooperative atmosphere downtown. Somebody who doesn't like it, not enjoying it, is enough to make the whole thing illegal, apparently, and therefore also tumultuous, which carries a very specific legal connotations, a riot and unlawful assembly. I don't think so. Again, they go on to say, to ask the justice to take specific and special note of the limitations to charter rights. Again, the last living signatory to that document present at the convoy, Mr. Brian Peckford, and he even gave a speech talking about Section 1 and the intention of the limitations on the charter. As someone who was a witness to its creation, I think we should take what he says over that. But that's just my opinion. What do I know? I'm just Patriot Smoothie, a guy who's been there the whole time, a guy who you guys love to listen to. Thank you so much, by the way. If you're enjoying the video, smash the like button below, leave a comment letting me know what you think, and subscribe to the channel. It helps a lot. And they go on to say that the defense did not mention the limitations at all. They add that blocking or obstructing roads is illegal. Again, we heard a lot of testimony how there was a lot of effort to maintain those emergency lanes and to keep the roads open as much as possible, considering the volume of people who came from across Canada to protest in Ottawa for very valid reasons, in my true and humble opinion. And we've heard a lot about that. That's been a huge portion of this trial, is the maintaining of those emergency lanes on Wellington, on the SJAM, on we know we had some problems on Kent, on Bank Street, and we know they were able to do it on the other streets, by and large maintained, I think, which was something that's a factual piece of fact. It's a fact that it was maintained by and large. The Crown submits that the actions, just because actions are peaceful does not make them lawful. It just goes on again. This is the same thing that we just heard for. And then they say the defense omitted important context in their submissions. Well, I think the Crown omitted some important things too. So, something called evidence has been omitted. That's a joke. Don't hate me too much. It's not really a joke. But another direct quote where the Crown took issue with the use of Justice McLean's February 7th and then consecutive following February 16th decision, the Horn injunctions, where he said that they remain at liberty remain at liberty to engage in peaceful protests. And Justice Perkins McVeigh says that that is very similar to the word continue, because I guess the Crown was trying to argue that the Justice McLean never said that they could continue protesting. But then, Justice Heather Perkins McVeigh basically responding, well, actually, remaining at liberty is very semantically similar and legally similar to the word continue. I don't think they landed that counterpoint there. All right. And then we go back to the photos of Wellington Street that the Crown mentioned between January 29th and February 10th. The Crown says that the evidence of what was happening on the ground, Perkins McVeigh can infirm anything. So just look at these pictures. There's some trucks here. There's people here. That means Chris Barber and Tamara Lich are guilty, apparently. I know this. We're almost done, guys. One more thing so again, another emphasis on the figurative megaphones that Lich and Barber wielded can be inferred by what was occurring on the streets. Perkins McVeigh asks, how can we know? Very good point, because it is up to the Crown to prove the burdens of evidence here. The burdens of proof are on the Crown to make their case beyond a reasonable doubt. They can't just say, well, we think it, we thought it, we charged them, so therefore they're guilty. It doesn't work like that. You got to present solid evidence that proves the things that you were saying. And just to say that Lich and Barber had this total control, there's been very little demonstrated evidence, if anything. I think maybe the only person who tried to show that was maybe, if I think back to Zexi Lee, where she was trying to mention something about a TikTok video where one of them said stop honking, and then she tried to testify that the people did that. I think that was the only thing the Crown presented in the entire case that tried to demonstrate that Tamara Lich and Chris Barber had actual command and control of the protest, the king and queen of the convoy, if you will. But I don't think it landed. It just didn't. After all the other contradictions in that specific testimony and everything else, I mean, there's no evidence that they had this big megaphone, that this big command of the protest. It wasn't there. It just wasn't there. And the Crown, so Perkins McVeigh says, how can we know, in the Crown saying that they had the figurative megaphones? And the Crown responded that we can see the effect through what they said and the goings on the streets. Where's the evidence? Where's the evidence of that? And then they said that the Crown says that this is a protest firmly planted for 3 weeks, and that doesn't happen by accident. No, it happened by grassroots because people were frustrated with the conditions in the country, and they went to the center of the government of Canada, the capital of our country, Ottawa, to make their voices heard for their unbearable and an uncontinuable living situation that they were brought upon and into. And Perkins McVeigh responded appropriately, in my opinion, but not all of the people were working in tandem. One last thing, another quote where the Crown was talking about the evidence of multiple convoys, and he says that multiple convoys does not equate to multiple purposes. And then Justice Heather Perkins McVeigh ended by saying that the Crown is now entering into speculation. In my opinion, they did that quite a long time ago. If you followed this all the way through, please leave me a comment. Tell me what your favorite color is, and also tell me what you think about all this. This is a lot to process. This was a very interesting day 30. I will be back again for day 24 to tell you about that. Hopefully it's not as heavy, but I really wanted to deconstruct this one and get through it with you. Leave a like, leave a comment, subscribe, and I'll see you next time on Patriot Smoothie.